My name is Ona, and I work for Aspen Adult Services. We're a nonprofit in Helena and in Bozeman that assist people with disabilities in two main areas: supported employment and supported living. We've created several public service announcements to help people and their families navigate resources that are available to them. I want to introduce you to Stefan Kolis from Montana Elder Law in Missoula, Montana. Stefan specializes in helping families prepare for the future. Some of the things that he talks about in this video are special needs trusts, supplemental trusts, long-term care, estate plan, and what happens if a family doesn't have a plan for their disabled child. As always, thanks for watching. Please share with others and leave us a comment as to whether or not this was helpful.
My name is Stefan Kolis. I'm managing attorney at Montana Elder Law here in Missoula. I write estate plans for average Montanans, and I help people plan for long-term care. Generally, that means we try to help people put together a plan about how they're going to pay for care in the home, at an assisted living or memory care, and maybe even at nursing homes. For pretty much every estate plan I write, I'm going to put in what we call a supplemental needs trust. And that is a provision in a plan that simply says, if someone is disabled and on public benefits when they stand to inherit, then they're not going to get their share outright. Their share is going to be held in a trust to take care of them with the benefit of not kicking that disabled person off of their Medicaid or their SSI, both of which are means-tested public benefits.
What happens if parents don't have a plan?
Assuming parents have assets and they have a disabled child who is on, say, Medicaid or SSI, when the parents pass, Montana law says everything is going to pass to their kids. For a disabled child who's on public benefits, that means that that disabled child is now getting a chunk of money. And both Medicaid and SSI have asset thresholds which say you can't have more than $2,000 of assets. The inheritance will count as an asset, and so what happens is the disabled children get kicked off of the public benefits that they were relying on.
What happens if the disabled child is not able to take care of that estate or to do any of that, and there's not a family member available to do that?
That's part of what all of this planning tries to create answers for. But if you don't have a plan, then eventually someone is going to have to petition the court to get guardian and conservatorship over the disabled individual to manage their money and make decisions in their best interest. When we write an estate plan, we try to avoid that and choose the people we trust, who the disabled children have a relationship with, so that the care goes as seamlessly as possible.
What kind of lawyer does a family need to connect with in order to do this?
Generally speaking, this field is what we would call estate planning and or elder law. Not every attorney is going to be comfortable writing what I call a supplemental needs trust or a special needs trust. And so you need to be asking the attorney you're working with if they have plans for disabled children.
What's a piece of advice that you would give families, or more than one piece, on things to avoid?
That is a great question. Generally speaking, the internet has all sorts of information out there. Some of it's good, some of it's bad. And so you can do your own research, but at some point, having someone who works in the field makes a huge difference. Traditionally speaking, for folks who had disabled children and wanted to keep the kids on the public benefits when the parents passed, the solution was disinherit your child. And that would effectively make sure your disabled child stayed on the public benefits, but that's a terrible outcome. And so we don't recommend that people do that. We recommend that they have the right plan to plan around the public benefits.
And every family situation is going to be different.
Yep, every family is different. These, you cannot just go out and find a form that's going to solve this problem. You got to really know the key issues with each family. You got to know the assets. You got to know what kind of care the child's going to need. And so the cases end up being very, very case, detail specific.
What are generally the main kinds of trusts that could be written in a plan?
Sure. For individuals who are disabled and on public benefits, I think about them as being two different trusts. One trust is established by parents and family members, which say, when I pass, these assets are going to go to my disabled child in trust, and that trust is written specifically to ensure that the money is used to supplement the disabled person's needs. The other kind of trust is called a special needs trust, and this trust is established by the disabled individual themselves or a court or a parent. And that trust specifically allows the disabled person to put money into this trust to not incur penalty periods for Medicaid or SSI, and to stay on the public benefits. That special needs trust, however, has to be written according to federal law. And the major fact that people are aware of with the special needs trust is it's got to have a payback provision to Medicaid, which says once the disabled individual passes, the first person who gets paid is Medicaid.
What can the average family do? And by average family, I mean family who couldn't come, doesn't have the resources to come hire a lawyer. What can they do to ensure that their disabled adult child is taken care of when they pass away?
Sure. So most estate planning attorneys are going to offer free consultations. So that is always going to be my first recommendation. You talk to the attorney, tell them your financial situation. Oftentimes we can figure out ways to make your plan work. If you really want to handle this on your own, the Supreme Court has documents that are available for free at www.courts.mt.gov. And that would include a financial power of attorney, a healthcare power of attorney, and a will that would nominate a guardian to take care of your disabled child. That, from a basic standpoint, is where you should start.